committee will come to order. Without objection, the chair is authorized to declare recess of the committee at any time. Pursuant to notice, I now call up H.R. 2262, the IG Empowerment and Independence Act. The clerk will report the bill, which was distributed in advance.
H.R. 2662, the IG Independent and Empowerment Act.
Without objection, the bill is considered read and open to amendment at any point. The chair recognizes herself to offer an amendment in the nature of substitute, copies of which have been distributed electronically to all members in advance. The clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 2662, offered by Ms. Maloney of New York.
Without objection, the amendment is considered read and will serve as base text for purposes of amendment. I now recognize myself for 5 minutes on the amendment. H.R. 2662, the IG Independence and Empowerment Act, is a package of critical reforms to strengthen the independence and authority of federal inspectors general. I introduced this bill with Leader Hoyer, Subcommittee Chair Connolly, Subcommittee Chair Lynch, Vice Chair Gomez, Congresswoman Porter, and Congressman Liu. The IG Independence and Empowerment Act contains a bill that I authored last year to protect IGs from political retaliation. This reform would allow an IG to be removed only for a documented cause, based on a defined list of legitimate, nonpartisan reasons, such as malfeasance, knowing violation of the law, or gross mismanagement. I introduced this provision last year after the previous administration retaliated against multiple IGs. Last April and May, President Trump fired the IGs for the State Department, the intelligence community, after they conducted oversight of the President and his top advisors. This legislation would ensure that IGs are protected against this type of retaliation and for just doing their jobs of oversight. Supporting IGs and ensuring that they can perform their work with independence and access to information has long been a bipartisan issue on this committee. The IG Independence and Empowerment Act contains measures that this committee has reported out favorably in the past with unanimous bipartisan support. One example is the IG Subpoena Authority Act, which was introduced this Congress by Vice Chair Gomez to give IGs the ability to compel testimony from contractors and former federal employees. This provision includes bipartisan compromises worked out years ago between Chairman Issa and Ranking Member Cummings. Another bipartisan measure in this bill is the Integrity Committee Transparency Act, which was introduced by Chairman Conley and Ranking Member Hieist, and which this committee approved unanimously earlier this month. This also includes the IG Access Act to provide greater accountability for Department of Justice attorneys by closing the loophole that prohibits the IG from initiating attorney misconduct investigations. This was introduced by Congresswoman Ross with bipartisan support from Congressman Issa, Subcommittee Chair Raskin, myself, Subcommittee Chair Conley, Subcommittee Ranking Member Hieist. The IG Independence and Empowerment Act also includes Congresswoman Porter's provision to ensure that temporary acting IGs are independent and qualified to serve in their role. And finally, a common sense reform proposed by Congresswoman Spear that would enhance training for IGs is included in the substitute amendment being considered by the committee. Components of this bill have received strong support from the National Taxpayers Union and R Street Institute. In a letter to the committee, these groups highlighted support for several pieces of this bill and urged us to work together on a bipartisan basis to enact needed reforms to strengthen IGs. Without objection, I would like to place their letters into the record. So ordered. We also received a support letter from DOJ Inspector General Michael Horowitz with helpful background on provisions of the bill that would allow his office to investigate DOJ attorney misconduct, and provisions that would grant IG testimonial subpoena authority. Without objection, I will place that letter in the record. So done. IG Horowitz wrote, and I quote, "I encourage all members of the committee to support these important reforms. In the long bipartisan tradition of this committee on such matters, and to improve government effectiveness and accountability," end quote. Finally, the Project on Government Oversight, or POGO, sent a letter urging the committee to approve this bill, and without objection, I will place that letter also into the record. POGO Executive Director Danielle Bryan wrote, and I quote, "The IG Independence and Empowerment Act represents a comprehensive approach to some of the biggest issues the Inspector General community faces today. I urge Congress to prioritize enacting it," end quote. I thank all members who worked on pieces of this bill, and I urge every member of the committee to support it. Who else seeks recognition?
Madam Chair.
Mr. Comer, the ranking member, is now recognized.
Madam Chair, I appreciate your work to empower our inspectors general to root out waste, fraud, and abuse, and mismanagement in federal agencies. And parts of this bill are steps in the right direction, but many of us remain concerned about some of the provisions in this bill. IGs have a dual responsibility to their respective agency and to Congress through the notice of requirements. Therefore, IGs straddle the executive and legislative branches. When the political parties of both branches are different, political fights can erupt, and recently this has led to a regrettable politicization of IGs. That is why we should keep the current balance by allowing the president to remove IGs, but requiring notice to Congress. Title I in this bill would dramatically limit the president's ability to remove an IG, shifting the balance. Keeping the current system would enable Congress to use its own oversight authority if it believes there is wrongdoing by the president or agency head in the removal of an IG. Next, in Title III, the majority has proposed to dramatically limit who can be appointed as an acting inspector general if the IG is voluntarily left office and then removed. In doing so, this hinders the president's ability to appoint an IG with whom they have confidence. While I'm open to discussing concerns about IGs serving at multiple agencies, this provision goes too far in limiting the president's authority over a subset of executive branch employees. Finally, I have serious concerns with the Title V provision authorizing an IG to issue testimonial subpoena authorities to compel testimony from former employees. While it may be helpful for IGs to investigate certain allegations of misconduct, it also provides IGs with a tool that can be easily abused for political purposes. For example, this authority would enable new Biden-appointed inspectors general to subpoena former Trump administration officials under the guise of any investigation, regardless of the real purpose for the investigation. Finally, this provision provides no due process protections for former federal employees, instead forcing them to pay for counsel to defend against and respond to these subpoenas. Without meaningful protections to ensure that testimonial subpoena authority would not be used to seek out political retribution, I cannot support this provision. Rooting out waste, fraud, abuse, and misconduct is one of the most important jobs of this committee, and inspectors general serve on the front lines with us in that mission. We must ensure that all of our inspectors general have the tools they need to conduct robust oversight of their respective agencies. This bill has many positive provisions, including ones that have already been passed through this committee and the House. But there's still work to be done to ensure adequate protections are in place and unintended consequences are avoided. This is why some of my colleagues will be offering amendments today to strip out the provisions that require further negotiation. I'm hopeful my Democrat colleagues can stop the repeated attacks on the Trump administration and focus on ensuring our inspectors general are able to conduct robust oversight or look for other solutions to ensure that all agencies have a watchdog capable of overseeing agency operations and spending. Madam Chair, I yield back.
Madam Chair.
Seeks recognition. Mr. Conley, you are now recognized.
Thank you, Madam Chairwoman. And thank you for your leadership on the IG Independence and Empowerment Act. The ranking member wants us to forget 4 years of history where at least 7 IGs were summarily removed and influence brought to bear to try to quash independent examinations that were legitimate subjects of inquiry by independent inspectors general. This isn't just about that administration. This is about the future. This is about the Congress reasserting its role in an institution we helped create. Inspectors general must be independent to do their jobs. And in my view, they must have subpoena power. They have to use it wisely. So do we in Congress. I sat during Congresses in which the subpoena power was grossly abused by our committee, as a matter of fact. On the other hand, I've also sat in Congresses where the legitimate use of subpoenas was ignored by administration officials. I don't think either one is an acceptable outcome. But enhancing the power of inspectors general to me is critical if we're going to have the kind of oversight and watchdog role that we in the legislative branch must have. And having inspectors general who are autonomous, who cannot by whim or by political influence be silenced by their removal. Inspectors general by their nature make agencies and officials in agencies uncomfortable because they are scrutinizing behavior. That scrutiny is essential for accountability, for efficiency, and for rooting out waste, fraud, and abuse throughout the federal government. The bill we're going to be considering today, and I'm going to support, and I'm going to oppose the amendments to weaken it, does just that. It restores the imbalance we allowed in recent history. And going forward, it makes sure that no president, no administration, Democrat or Republican, can by whim or flimsy rationale remove an inspector general, especially in the midst of an investigation. I think that that independence, that autonomy, and the enhanced power with limited subpoena power, I think is really critical to our mission as the Oversight Committee, because we're partners with the IGs. We have oversight of them. So I thank the Chairwoman for bringing up this bill. I'm proud to be an original co-sponsor. I'm glad several of my provisions are included in the bill, and I look forward to voting for it and resisting any attempt to dilute or weaken it. I yield back.
Seeks recognition. Is there any other member who seeks recognition? Does any other member have an amendment to the bill?
Madam Chair?
Mr. Biggs.
Yes, Madam Chair, thank you. I have an amendment at the desk.
The clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 2662, offered by Mr. Biggs of Arizona.
Without objection, the reading of the amendment is dispensed with. The gentleman is recognized to explain his amendment.
I thank the chair, and H.R. 2662 has many provisions with bipartisan support. However, there are 3 titles that Democrats have included which Republicans ought not to and cannot support today. The first provision this amendment removes is the limitation on the president's authority to remove an inspector general. It is important to ensure that inspectors general are protected, but by dramatically limiting the president's authority to terminate an IG, we risk the situation that a president will be unable to remove an IG who has engaged in misconduct that does not rise to the level of this particular provision, but does illustrate a lack of capability to lead an IG office. The second provision this amendment removes is the limitation on the appointment of a replacement acting inspector general when an IG voluntarily departs or is involuntarily removed, insisting that the first assistant to an IG be the person who takes over as acting inspector general is short-sighted and may result in individuals in being appointed who are not qualified or competent to serve as an acting inspector general. And the third provision this amendment removes is the authorization of an inspector general to issue testimonial subpoenas to compel the testimony of former federal employees. While testimonial subpoena authority may be helpful for IGs to investigate certain allegations of misconduct, it provides a tool that can be easily be abused for political purposes. And we must ensure that there are robust protections in place to prevent the misuse of this tool and to ensure that former federal employees receive adequate due process protections. And so what my amendment does is it amends the bill to remove the poison pills that have been placed in here, and ensure that only provisions with bipartisan support remain in the package bill. To repeat, it removes one, the Title I provision limiting the president's authority to remove an inspector general to 9 specific options. 2, it removes the Title III provision limiting who may be appointed to become an acting inspector general. And it also removes 3, the Title V provision that would enable inspectors general to compel the testimony of former federal employees. Madam Chair, I think this is important. This amendment is important. I encourage members to choose the bipartisan way of making an inspector general reform. And that's what my amendment would do, is include all the provisions that both sides support. And with that, Madam Chair, I will yield back.
The gentleman yields back. Who else seeks recognition? Katie Porter, you are now recognized.
Thank you so much, Madam Chair. This amendment to the Inspector General Independence and Empowerment Act would remove an important good government reform that would prevent unqualified acting inspector generals from assuming these important roles. And my colleague, Mr. Biggs, just said that we don't want to have people who are incompetent or short-sighted, people who are not qualified in the role of inspector general. But definitionally, somebody who is a political appointee is, in fact, unqualified to be an inspector general. And so what this amendment would do is try to strip out the provision in the bill that forbids dual hatting, serving as both a political appointee and an acting inspector general at the same time. And Mr. Comer is correct that IGs do straddle the legislative and executive branches, but that is precisely why it is not ever acceptable to have a political appointee in an IG role, because they cannot straddle the 2 branches if they are a political appointee of the executive branch rather than an independent inspector general. So it's an inherent conflict of interest to have this dual hat, to be both a political appointee and an acting inspector general, and it compromises the legally required independence of the inspector general and the work of their office. Rooting out waste, fraud, and abuse is not just a talking point. It is a reality of the work that inspector generals are supposed to do. And somebody who is a political appointee of an administration will not appear to, and may not in fact have, the necessary independence to be able to do that work. They might come to Congress and say that they're rooting out waste, fraud, and abuse, and that they understand the role of the inspector general, but they will not do the work of actually doing it. And I want to point out that the Senate bill that's equivalent to what we're talking about today, containing almost identical provisions, is led by Republican Senator Chuck Grassley. It has the support of 7 Democratic and 7 Republican senators. It is the definition of bipartisan. I grew up in Iowa, and I can remember Senator Grassley championing the importance of rooting out waste, fraud, and abuse. He was a real inspiration to me in that regard in my own decision to pursue government service. And so because I support both Senator Peters and Senator Grassley, and everyone on both sides of the aisle who wants to root out waste, fraud, and abuse, who wants to protect the integrity of the Inspector General program in Democratic administrations and in Republican administrations, in Biden administrations and Trump administrations. I don't care what political party the president is, Inspector Generals should not be political appointees. I'm disheartened that we are even debating this amendment, given how strongly the bipartisan support is for making sure that acting inspector generals are not allowed to wear two hats, are not allowed to be political appointees. And to strike this provision would weaken the very, very purpose of the entire inspector general program, and which is really at the heart of our oversight responsibilities that we are tasked with for the American people. So I strongly urge a no vote on this amendment, and I yield back.
The gentlelady yields back. Who else seeks recognition?
Congressman Gomez seeks
Okay,
recognition.
Congressman Gomez, you are now recognized.
Thank you, Madam Chair. This amendment would remove a provision that I introduced this Congress, which has long been a priority for inspector generals to allow for a thorough and complete investigation. The Council of Inspector Generals on Integrity and Efficiency stated in a legislative priority sent to the committee this year, quote, OIG oversight can be substantially hampered by the inability to compel the testimony of witnesses who have information that cannot be obtained by other means. One of my colleague on the other side of the aisle called this a poison pill, but I want to just point out that this provision has always been a bipartisan before, and the House passed this same language unanimously in 2018, and it was actually introduced and authored by a Republican colleague, Representative Russell. So this is not a poison pill. It is something that has been supported by both sides of the aisle and passed unanimously out of this committee. Additionally, this legislation provides procedural safeguards to ensure that subpoena authority is not abused and it does not interfere with ongoing investigations. For example, the bill would require an inspector general to obtain the approval of a panel of 3 other inspector generals in order to issue a subpoena for testimony. So I strongly urge a no vote on this amendment, and I yield back. Thank you so much.
Who else seeks recognition? Does anyone else seek recognition? I now recognize myself.
No, you're right.
Wait,
What's that?
is there someone seeking recognition?
I have, if we're done with the Biggs amendment, I have an amendment at the desk also.
Okay,
Representative Keller.
we're not done with this amendment. We'll get to you after
All right,
this
thanks.
amendment. I now recognize myself. I oppose this amendment, which would gut this legislation by removing 3 important reforms. The amendment would strike the bill's protections that would only allow an IG to be removed for one of a specific set of causes. We saw last year when President Trump retaliated against IGs who were investigating his administration, including when he fired State Department IG Steve Linick, how unlimited authority can be abused. These protections are constitutional. Last month, the Independent Congressional Research Service released an analysis of congressional authority to limit the removal of inspector generals and concluded that for cause removal restrictions, quote, appear to be a constitutionally permissible means of encouraging independence for most IGs, end quote. This amendment would also strike a requirement that acting IGs come from an office of Inspector General. The Council of Inspectors General on Integrity and Efficiency requested this reform, proposed by Representative Porter, as one of its top legislative priorities in order, and I quote, enhance the independence of the Office of IGs, end quote. We saw serious abuses during the last administration when in both the Department of Transportation and the Department of State, President Trump named political appointees within the agency to serve as the acting IG overseeing that same agency. This amendment would strip from the bill an important reform that would allow IGs to issue a subpoena to require an individual outside of the federal government to provide testimony if needed for an investigation. This has long been a priority for IGs to allow thorough and complete investigations. These provisions were passed by the committee and House in 2018 in a Republican-led bill and included compromises worked out on a bipartisan basis. A few IGs, including the Department of Defense Inspector General, already have this authority. In language I authored and that this Congress passed on a bipartisan basis, the Pandemic Response Accountability Committee was provided testimonial subpoena authority when it was created as part of the CARES Act last Congress. There are many instances of former officials and non-governmental employees avoiding IG interviews going back over decades. For example, IGs were unable to interview retired agents in the Fast and Furious investigation and non-government witnesses in the Carter Page FISA warrant investigation. This has never been a partisan issue before. In a letter to the committee sent yesterday, the Department of Justice IG, General Michael Horowitz, wrote, and I quote, "I strongly support granting IGs testimonial subpoena authority because the absence of such authority hinders the ability of IGs to conduct complete and necessary oversight. Without this authority, IGs are unable to obtain potentially critical evidence from former federal employees, employees of federal contractors, and grant recipients and other non-government witnesses unless they voluntarily agree to be interviewed. I strongly urge a no vote on this amendment, and I yield back." Who else seeks recognition? Okay, the question now occurs on the amendment offered by the gentleman from Arizona. All those in favor say aye.
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 All those opposed say no.
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 In the opinion of the
never.
chair, the noes have it, and the
Madam
amendment
Chair?
is adopted.
Madam Chair,
Yes, Mr. Comer? Mr. Biggs?
thank you. I request a roll call.
A recorded vote has been requested. A recorded vote is so ordered. And pursuant to Clause 2 of Rule 7 and Committee Rule 5B, proceedings on this amendment are postponed. Is there further discussion or further amendments?
I have an amendment,
Mr.
Madam Chair.
Keller, you are now recognized.
Thank you,
The
thank you,
clerk-
Madam
the
Chair.
clerk- First, let's have the clerk report your amendment, okay?
Amendment to the amendment in the nature of a substitute to HR 2662, offered by Mr. Keller of Pennsylvania.
Without objection, the reading of the amendment is dispensed with. The gentleman is recognized to explain his amendment. Mr. Keller.
Thank you, Madam Chair. And as has been discussed, there are provisions of this bill that are bipartisan. However, there's a few things that are troublesome in the bill and should not be supported or
Where's
be
mine?
supported by the Republicans and shouldn't be supported by anybody in the
Get the
committee.
talking points for our next.
And
This is his amendment.
excuse me, I'm sorry, I heard some noise there. Anyhow, the bill, there's reasons not to support some parts of this bill, while there's some bipartisan measures in this. My amendment would be very similar to Mr. Biggs' amendment in striking the Title I provision limiting the president's authority to remove an inspector general to 9 specific options, and 2, striking Title II provision limiting who may be appointed to become an acting inspector general. It also amends Title V differently than what Mr. Biggs did. I'm amending Title V rather than striking it, and it would make subpoena authority prospective and preclude the use of officials' administration. So what I would do is further, this amendment would ensure that any former federal employee who is subpoenaed has access to legal counsel by requiring the IG to cover their legal fees. This will provide an additional safeguard to the use of the new authority and help ensure that only the most necessary subpoenas for an investigation are issued. This amendment would add another barrier to politically motivated investigations and preserve certain authorities of the president. I urge my colleagues to support this amendment, and I yield back.
Gentleman yields back. I now recognize myself, and I agree with Mr. Keller that this amendment is very similar to the prior amendment. I oppose the prior amendment, and I oppose this amendment. which would strike the important protection in the underlying bill that would only allow an IG to be fired for cause, and the provisions requiring qualified, independent employees to serve as acting IGs. I will not use up time addressing my concerns since I summarized them during debate on the previous amendment. This amendment, however, would make new unvetted changes to IG subpoena authority. Perhaps because they have not been vetted, these provisions would create a bizarre scheme in which only federal employees who are working for the government on the date of enactment could be held accountable. This would mean no past federal employees or future federal employees could be held accountable. The Republicans' amendment would require an IG to pay the legal fees using taxpayer money of any individual, no matter how bad of an act they may have committed. This could include employees under investigation for such acts as child pornography, possession, sexual misconduct, gun trafficking, or contractor fraud.
Oh.
These are not hypotheticals. These are real examples of witnesses that IGs could not interview because they lacked subpoena power to compel testimony. My colleagues on the other side used to care about accountability. They used to be upset when IG reports said that an official resigned or retired before being interviewed so that they could avoid that obligation. Apparently, they now would like taxpayers to pay the legal fees of sexual offenders. I strongly urge a no vote on this amendment, and I yield back. Who else seeks recognition?
Madam Chair.
Mr. Higgins? Is that Mr. Biggs? Is it Mr. Biggs?
Yes, ma'am.
Mr. Biggs seeks recognition. You're now recognized.
I think.
You're now
Thank
recognized.
you, thank you, Madam Chair. I appreciate that. I just wanted to express support for Mr. Keller's amendment. I think it's a good amendment and a wise amendment, particularly when we get back to Title I of this piece of legislation. And I've heard the chair and the others talk about the previous administration, the Trump administration, terminating Inspector General in a way that you didn't find acceptable. I just want to remind you that in 2009,
The gentleman is, if you will unmute, we cannot hear you.
good grief. Thank you.
Okay.
Thank you, Madam Chair. So I rise in support of Mr. Keller's amendment. I think it's a good, an amendment well taken. And particularly with regard to Title I. And one of the things that I think is so important is I've heard repeatedly the disapprobation that the other side had with the termination of several inspectors general by President Trump. And I would just add to this now, in 2009, when President Obama fired Gerald Walpin, who was the Inspector General of the Corporation for National Community Service, in particular, looking over AmeriCorps, what he said is that he had basically lost confidence in Mr. Walpin. And there did not seem to be the same disapprobation from my colleagues across the aisle at that termination. I think that the Title I here is unduly restrictive and provides constraints that aren't necessary, and also will lead to the elevation of some who may not even be qualified whatsoever to be the Inspector General. And so with that, I support Mr. Keller's amendment and urge everyone else to vote yes as well.
Gentleman yields back. Does anyone else seek recognition?
Madam Chair.
Madam Chairwoman.
Mr. Gomez, you're now recognized.
Madam Chair, I speak in opposition to this amendment. At the 11th hour, my Republican colleagues are proposing new changes to the IG subpoena authority. As we have heard, these changes would mean no past federal employees or future employees could be held accountable through compelled testimony. This could mean that past and future employees could avoid accountability no matter how bad their wrongdoing was. This amendment would have taxpayers pay the legal fees of any person an IG wishes to subpoena. The amendment does not even specify that the IG has to serve the subpoena. And I want to be clear that the Department of Defense Inspector General currently has the authority to issue subpoenas. And on multiple occasions, the IG has approved a subpoena but not issued it following agreement by a witness to testify voluntarily. This amendment would have taxpayers cover legal fees with no limits for any witness in any IG investigation for whom the IG is even considering a subpoena. This bill, to be very clear, used to be bipartisan, and I hope we can make it so again. But these ill-advised provisions are not helpful or constructive to this debate. I strongly urge a no vote on this amendment. I yield back.
The gentleman yields back. Does anyone else seek recognition?
Madam Chairwoman,
Mr. Conley, you are now recognized.
just real briefly, thank you, Madam Chairwoman. I wanted to respond to the argument made that we need to give more flexibility to the executive branch. If there's anything we've learned over the last several years, it's the opposite. It is that the executive branch, and we're going to be taking up other bills today that also tried to codify restoring the balance of power. We are a separate but co-equal branch of government. The executive has enormous power, both by implied powers and explicit powers granted by the Congress or just seized. If we're going to preserve the independence of inspectors general, this codification is essential, whether it's for Democratic presidents or Republican presidents. And I don't believe any president, whether it's President Obama, President Trump, President Biden, ought to be able to remove an IG simply because, quote, we're not comfortable with him or her, unquote. And this bill solves that problem. And I really do believe that if we don't pass this kind of legislation, my friends on the other side of the aisle will someday live to regret it. I yield back.
The gentleman yields back. Does anyone else seek recognition? The question now occurs on the amendment offered by the gentleman from Pennsylvania. All those in favor say aye.
Aye.
All those opposed say no.
No.
In the opinion of the chair, the noes have it, and the amendment is not adopted.
Madam Chair,
Yes,
may I request a recorded vote, please?
yes. A recorded vote has been requested. A recorded vote is so ordered and pursuant to Clause 2 of Rule 11 and Committee Rule 5B. Proceedings on the amendment are postponed. Is there further amendment or discussion? I now call up H.R. 302, the Preventing a Patronage System Act. The clerk will report the bill, which was distributed in advance.
H.R. 302, the Preventing a Patronage System Act.
Without objection, the bill is considered read and open to amendment at any point. The chair recognizes herself to offer an amendment in the nature of a substitute, copies of which have been distributed electronically to all members in advance. The clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 302, offered by Ms. Maloney of New York.
Without objection, the amendment is considered read and will serve as a base text for purposes of amendment. I now recognize the sponsor of this legislation, Mr. Conley, for 5 minutes.
Thank you, Madam Chairwoman. Here's another bill where we're trying to restore the balance between the branches of government and reasserting the role of Congress in controlling, in this case, the civil service protection system. Since the creation of the civil service in 1883, administrations, Republican and Democrat, have established an accepted service schedule only 5 times. Those accepted service categories are created for positions that require unique hiring or operating rules, like for positions of a short-term political nature or positions in remote areas where there's a critical hiring need so great that competitive civil service rules won't work. In those limited cases, individuals hired into positions classified in the accepted service are not vested with civil service appeal rights because they have not undergone the required competitive hiring process. On October 21, last year, the then president signed Executive Order 13957 to create a 6th accepted service schedule, Schedule F. This executive order undermined the merit system principles of our federal workforce entirely by requiring agency heads to reclassify policy determining, policy making, or policy advocating positions to a newly created Schedule F category that actually removed the due process rights and civil service protections of existing employees in their existing positions. One agency, the Office of Management and Budget, planned to reclassify about 400 staff positions to Schedule F, accounting for approximately 80% of the entire agency's workforce. In one of his first executive actions, President Biden signed Executive Order 14003 on January 22nd of this year, making it a priority to revoke Schedule F and prevent any president from having additional authority to hire political cronies or fire qualified officials and experts. The danger remains, however, that future administrations could attempt to erode the foundation of our merit system principles by resurrecting Schedule F or something similar to it, with additional accepted authorities to circumvent competitive hiring. The Preventing Patronage System Act is a bipartisan bill that would protect merit system principles by limiting federal employee reclassifications to the 5 accepted service schedules in use prior to fiscal 2021. The bill would also prevent any position in the competitive service from being reclassified to an accepted service schedule that was created after September 30th of last year, and would freeze the rules and guidance that define accepted service schedules to be interpreted as they were on September 30th of last year. Future administrations would be required, as I believe they should be, to come to Congress before making such sweeping changes to the workforce. If Congress concurs, you can go ahead. And Congress would have to create those new accepted schedules in statute at the request of the executive. The bill is endorsed by the American Federation of Government Employees, the National Treasury Employees Union, the National Active and Retired Federal Employees Association, the Senior Executive Association, the National Federation of Federal Employees, and many other employee associations and good government groups. I want to thank Representative Brian Fitzpatrick of Pennsylvania, who is my original Republican co-sponsor on this bill, as well as other colleagues who are also co-sponsors. I think this is an important rebalancing. I think we have to insist that Congress is in the action here, that no executive unilaterally can do what was done with Schedule F in the future. I yield back.
The gentleman yields back. Mr. Comer is now recognized.
Thank you, Madam Chair. The Career Civil Service was originally created to support the policy and decision makers held by political appointees. These career civil servants held non-policy related positions. While in these important support roles, they were vital to helping implement the president's policies. As the executive branch has ballooned over the decades, more and more positions within the career civil service have grown in responsibility and power. But increased responsibility did not increase accountability. Instead, career officials in policy-related roles are often shielded from discipline, even if they are poor performers. The inability to discipline poor performance in the civil service undermines the president's ability to implement his policies and thwarts the will of American voters. To address this growing problem, President Trump issued Executive Order 13957. This executive order created the new Schedule F in the accepted service for career civil servants in policy-related positions. The executive order made it easier to take action against Schedule F employees up to and including termination for performance issues. The Trump administration did not create Schedule F to reinstitute a patronage system, as the bill's supporters have mischaracterized it. Had President Trump wanted to do that, he could have converted Schedule F employees into the same kind of at-will political employee that populates Schedule C of the accepted service. President Trump's executive order simply made it easier to discipline or remove civil service officials in policy-making roles who are poor performers or actively work to undermine the work of their politically accountable supervisors. In fact, the executive order avoided meddling with the senior executive service and also preserved protections for non-policy related civil service positions, precisely the types of positions that were the original object of the 19th century civil service reforms that eliminated the patronage system. And regardless of one's views of Schedule F, this bill is simply no longer needed. President Biden rescinded Executive Order 13957 immediately upon taking office. Further, federal personnel reforms that President Trump's executive order attempted to have been sorely needed and should not be precluded from a future administration. This bill only serves to entrench career bureaucrats who would potentially thwart the executive policy objectives of a duly elected president. I urge all my colleagues to oppose this bill. And I yield back.
Could I ask my friend a question? Would he yield for a question?
Sure, yes.
I hear what you're saying, but is it your contention that 80% of the employees of OMB were thwarting the will of the executive and should have been reclassified, if not replaced?
I don't know what percentage of the bureaucracy thwarted the will of the president, but when you are in those civil servant positions, you have to implement the policies of your supervisors. And that's what our issue is with your bill. You had bureaucrats, and that's a big problem with conservatives in America, fighting the bureaucracy. We pass bills in Congress, the president has initiatives, but the bureaucracy fights back. Some people would call that the deep state. They don't want to implement the policies that their duly elected supervisors try to implement, and it was creating a big problem.
I understand the point my friend's making. I would simply submit, but the effect to reclassify 80% of the entire workforce of OMB, I think, is not a good example of the deep state thwarting the will of the executive. I yield back.
Gentlemen, rules back. Does anyone else seek recognition? I now recognize myself for 5 minutes on the amendment. The Preventing a Patronage System Act, which is sponsored by excuse me?
Madam Chair.
Oh, Mr. Hieist. Excuse me, Mr. Hieist, I did not see your hand up. Mr. Hieist is now recognized for 5 minutes.
Thank you, Madam Chair. I have an amendment at the desk.
Okay, the clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 302 offered by Mr. Hieist of Georgia.
Without objection, the reading of the amendment is dispensed with. The gentleman is recognized to explain his amendment.
Thank you very much, Madam Chair. And I just identify with the comments of the ranking member a few moments ago. My colleague from Virginia, the bill basically would prohibit any president from adding a new schedule of civil service positions accepted from the competitive service. I get that, but with all due respect, very honestly, I just think this is the wrong way to go. And I say that really for two primary reasons. First of all, I believe that President Trump was on the right track when he issued the Executive Order 13957. We're all familiar with how some, not all by any means, but how some civil servants take it upon themselves to determine what federal policy will be. And in so doing, many times these individuals will undermine or thwart the policy directives of a president who has been given a mandate by the voters of this country. In fact, I think it's important, as has already been brought up, but to bring some more emphasis to it, if you will. After President Trump took office, the Washington Post actually ran a story about how federal employees were, quote, in regular consultation with recently departed Obama-era political appointees about what they can do to push back against the new president's initiatives, end quote. I mean, I think all of us, both sides of the aisle, would recognize that kind of behavior is problematic, regardless of who happens to be in the White House. We just don't need that type of resistance, if you will, taking place against a newly elected president. And this is something, and I will say that it's not something new to President Trump's administration. We have seen this type of thing certainly in the past, but I would also say and argue that it seems at least to have reached a peak with the Trump administration. So in response to that, President Trump came forth with the executive order 13957, and it moved civil servants in policy-related positions into a new Schedule F in the accepted service. And in this way, these individuals, these civil servants, instantly became more accountable. And I think in the end of the day, that's what is needed. That's what it's all about. Their job at the end of the day is to lend an elected president all the benefits of their areas of expertise in helping the president to implement his or her mandate from the voters. Their job is not to stand in the way of those initiatives by the president and to block the implementation of the mandates. And so Schedule F restores that kind of balance. And my amendment makes sure that that balance is maintained. In fact, I also plan to introduce a bill later on that would likewise reverse what I believe is President Biden's unwise decision to rescind this executive order. But supporters of my colleague's bill claim that Schedule F should never return because it reinstituted 19th century patronage system, which has already been discussed. But I just believe that's a gross misrepresentation of Schedule F. I believe it's a misrepresentation of this executive order. It does not reinstitute a patronage system. All current occupants of Schedule F would have remained in their positions. That's important for us to realize and understand. The order did not sweep them out of the way and replace them with other individuals. The order just made it easier for the executive branch to discipline or remove individuals, civil servants who willfully tried to undermine or tried to thwart the policies of a duly elected president. I don't see a problem with that. This is precisely the right approach. Again, we should work to codify it as my amendment does, rather than to prohibit it. My second point real quickly is my colleague's bill, in my opinion, needlessly binds the hands of all future presidents, not just from reestablishing Schedule F, but from establishing any other accepted class of civil servant positions. And I think this is important for us to remember that over the decades, before Schedule F ever came about, the executive branch found it necessary to establish 5 classes of positions accepted from the competitive service. So presidents have put forth the 5 that we currently recognize. And who is to say that any future circumstances would not reveal the need for additional exceptions? If we do, the president's authority to create a new class would be thwarted. And I think we need to give any and all future presidents the same right as other presidents in the past have had. Yet the bill would remove the president's discretion to be able to do this. So to me, that just doesn't make sense. And I would argue that this whole schedule needs to be codified and leave intact the president's authority to create other new classes if circumstances arise where that's necessary. And with that, I would urge my colleagues to support this amendment, and I yield back. Thank you, Madam Chair.
The gentleman yields back. I now recognize myself. I strongly oppose this amendment that strikes the entire bill and then replaces it with the codification of Schedule F. The language may look very similar because much of it is lifted directly from the executive order that President Trump issued on October 21st, 2020. President Trump's Schedule F would have severely undermined the integrity and expertise of the civil service by stripping them of their rights and protections. This is not how you build a strong and effective federal workforce. In fact, it is just the opposite of that. I support H.R. 302 and strongly oppose this amendment for the same reason. Schedule F was an attack on the merit system principles of the civil service. It sought to make senior career civil servants accountable only to pleasing the president. We must oppose this amendment and pass H.R. 302 to make sure that a proposal like Schedule F is never established. I want to say a few words about the underlying bill, the Preventing a Patronage System Act, which is sponsored by Congressman Conley, prohibits reclassification of federal employees in the competitive civil service to an accepted service schedule created after September 30th, 2020. On October 21st, 2020, President Trump signed an executive order creating a new accepted service schedule called Schedule F. It directed federal agencies to identify civil service employees whose positions were, quote, policy determining, policy making, or policy advocating in nature. These employees would then be recommended for transition to Schedule F. Federal employees transferred to Schedule F would have been stripped of their civil service protections and rights, making it easier to terminate them. Let's be honest about what this executive order would have done. It would have replaced our current nonpartisan, expert career civil service with one that was loyal only to President Trump. Science, justice, and defending our nation would have become subservient to personal loyalty to the president. Understandably, the creation of Schedule F was shocking to the more than 2 million federal employees who will all rely on every day for their experience, their expertise, and dedication to public service. Many members of this committee, including Mr. Conley and I, strongly condemned the executive order of President Trump as an attack against the merit system principles of civil service and a return to the spoils system of the 1800s. Fortunately, one of the first actions taken by President Biden when he came into office was to rescind that executive order. I commend President Biden for taking swift action before any positions were transferred to the new Schedule F. This bill would prevent this from ever happening again. It would fortify the protections of civil service employees, ensuring that they can continue to do their important nonpartisan work. I thank Mr. Conley for introducing this important legislation, and I urge all of my colleagues to support it.
Would the chair yield?
Who else seeks recognition?
This is Mr. Conley asking you to yield.
Okay, Mr. Conley, you are now recognized.
I thank the chair. Just real briefly, I think it's really important, and my friend from Georgia kind of glossed over this. We're not saying no president can ever do this. We're saying there's a process. You got to come to Congress. We get a mandate too. We get elected. And the president needs to consult with Congress like he is required to in so many other constitutional categories. And secondly, I would point out there's a certain irony in Mr. Hieist's proposed substitute. He would codify Schedule F, which in an odd way is an implicit concession to the point that Congress ought to give its approbation if we're going to have a new schedule. That's precisely the point of my bill. I thank the chairwoman for yielding.
Will the gentleman kindly yield?
I'm actually on the chairwoman's time. You would require her to yield to you.
Will the chairwoman?
I yield to Mr. Comer, to Mr. Hieist, excuse me.
Thank you, Madam Chair. And I appreciate the comments from a friend from Virginia. Yeah, but again, what my amendment is all about is accountability. That's the issue. And I'm sure you hear it too. there are a number of federal employees who themselves are frustrated that within their various areas, the poor performers, there's no discipline for them. And so what we're trying to put into play is the ability to deal with some of these poor performers, have some degree of discipline. And I even, wherever I placed it in my comment a while ago, from the Washington Post, an example of how strategically people came on board to try to purposefully thwart the desires of an elected president. We must have the accountability for the executive branch to be able to address those type of problems. That's all I'm trying to do. And I would think both sides of the aisle, regardless of who is in the White House, would want a president and the executive branch to have some degree of discipline and authority when it comes to their ability to implement the things that the American people have elected them to do. And with that, Madam Chair, thank you for yielding your time. I appreciate it.
The gentleman yields back. Mr. Biggs, you are now recognized. Mr. Biggs.
Thank you, Madam Chair. I support Mr. Hieist's amendment. I appreciate it. I think it's thoughtful. I think it's right. And I have to just point out something that I find intriguing. We don't know what the percentage of folks are that are in the federal bureaucracy that attempted to slow down President Trump any more than we know how many attempted to slow down President Obama or George W. Bush or President Clinton. We do know that it is present, though, however. And for instance, in an article that was written in 2017 talking about the attack effectively of the bureaucracy on President Trump's political agenda. And remember, President Trump was elected. He was elected and to make promises and regarding policy. So you would expect that the bureaucrats would endeavor to enact that policy. But this particular article, an investigation that they did, they found that at NOAA, the Securities and Exchange Commission, Secretary at the State Department, Energy Department, and the Defense Department, all of those departments had undertaken underneath the political appointees that the professional employees, the long-term employees had undermined the president and the political appointees processes. And they actually gave very specific examples and also indicated how they did it. They did it by continuing programs from the previous administration by simply changing the name. That's so they undermined that President Trump's political appointees. He couldn't get his agenda going as well as he would like. Second thing, they delayed implementation or slowed down. This is a tactic that was used by bureaucrats at that time. So how many of the 2 million federal bureaucrats engaged in that? I don't think any of us know, but we do know this, that it's real, it happens, and it happens under every administration for sure. And when Mr. Hieist talks about accountability, he's talking about accountability of these people who are unelected, but who are required to follow the policies that are enacted by the current administration. You would expect that people in the bureaucracy would be enacting the Biden administration, I would assume, just like I expected people in the bureaucracy to enact the Trump administration policies. This amendment gets at restoring accountability. And so I support it wholeheartedly. And Madam Chair, I would submit for the record an article published by Bloomberg entitled "Washington Bureaucrats Are Quietly Working to Undermine Trump's Agenda. Across the government, career staffers are finding ways to continue old policies, sometimes just by renaming a project," that was published December 18, 2017. And I'd ask that be part of the record. And with that, I yield back.
Without objection. The chair now recognizes Mr. Clyde. Mr. Clyde, you're now recognized for 5 minutes. Mr. Clyde of Georgia.
Thank you, Madam Chair. I appreciate that. I want to reinforce the comments of Ranking Member Comer and Subcommittee Ranking Member Hieist. I think the Hieist amendment is an excellent amendment to HR 302. You know, this amendment deals with politically accountable officials, those in policy positions. The amendment codifies reforms to make civil servants in policy positions more accountable, easier to discipline, and easier to remove for poor performance or insubordination. You know, when civil servants call themselves the resistance and fight against the new policies of a duly elected president, that's just wrong. They don't have the right to implement their own policy, only the policy of the elected official. You know, the president certainly needs to maintain the authority to hold civil servants accountable in all areas of policymaking positions. And so I urge my colleagues to support this amendment. And if this amendment does not pass, then I would urge my colleagues to not support this bill, and I yield back.
Gentleman yields back. Mr. Keller, you are now recognized. Mr. Keller.
Thank you, Madam Chair. I would like to thank Congressman Hieist for this amendment, which would enable federal agencies to hold federal employees in positions with significant policy authority more accountable, better recruit high-quality candidates to federal jobs, and more easily reward high performers. The Government Accountability Office reported in 2015 that it takes 6 months to 1 year to remove federal employees for poor performance. This is simply unacceptable. Federal employees and American taxpayers deserve a more modern and efficient government. This amendment allows federal agencies to improve and modernize employment procedures around career employees in policy relevant positions that have significant authority and influence in the issuance and implementation of policies and regulations that affect Americans on a day-to-day basis. This amendment will improve accountability, enhance transparency, and bring the federal workforce into the 21st century. The American people deserve a government that is more effectively delivers results for them, regardless of which political party occupies the White House. I appreciate Congressman Hieist and his dedication to the issue, and I urge my colleagues to support this amendment. Thank you, and I yield back.
The gentleman yields back. Who else seeks recognition?
Madam Chair.
And that is Mr. Norman. You are now recognized.
Thank you, Madam Chair. I just want to emphasize what's been said about Representative Heist's amendment. I think the comment about not building a team with this amendment is exactly opposite. The way you build a team is having competent people and being able to get rid of those who are not competent. I'll give you an example. In the public schools, a lot of the bad teachers are running out the very good teachers. And like Representative Keller said, it takes 1.5 years or longer to get rid of those who are not doing the job. So I think, secondly, his amendment enforces good teamwork. And secondly, I think that with this, it attracts people to serve which is, it's an honor to serve in government now. And so many times it's been opposite. You got unelected people who think they are the decision maker, and they're not. They serve at the pleasure of each administration. I don't look on this as Democrat or Republican. I look on this as common sense. I yield back.
Yields back. The question now occurs on the amendment offered by the gentleman from Georgia. All those in favor say aye.
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 All those opposed say no.
No, nay,
No.
never.
In the opinion of the chair, the
Madam
noes
Chair.
have it, and the amendment is not adopted.
Madam Chair,
Yes,
ask for a recorded vote, please.
the gentleman has called for a recorded vote. A recorded vote has been requested. A recorded vote is so ordered, and pursuant to Clause 2 of Rule 11 and Committee Rule 5B, proceedings on the amendment are postponed. I now call up H.R. 2671, the Performance Enhancement Reform Act. The clerk will report the bill, which was distributed in advance.
H.R. 2617, the Performance Enhancement Reform Act.
Without objection, the bill is considered read and open to amendment at any point. The chair recognizes herself to offer an amendment in the nature of a substitute, copies of which have been distributed electronically to all members in advance. The clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 2671, offered by Ms. Maloney of New York.
Without objection, the amendment is considered read and will serve as a base text for purposes of amendment. I now recognize the sponsor of this bill, Mr. Conley, for 5 minutes.
Thank you, Madam Chairwoman. I thank you for bringing up 2617, the Performance Enhancement Reform Act, for markup. The coronavirus pandemic has highlighted how IT modernization and evidence-based decision-making must be integral to the mission of the federal government. Each year, federal agencies are required by law to develop a performance plan that summarizes strategic goals and objectives, and to use the plan to align resources and to guide decision-making to accomplish priorities and improve outcomes. These performance plans should support planning across organizational operating units and describe how agency components are working toward common goals. Current law requires only the Chief Human Capital Officer to contribute to the creation of the performance plan, leaving much of the agency's leadership expertise outside of the planning process itself and exacerbating the lack of leadership collaboration that plagues so many federal agencies. Current law also does not ensure that agencies are incorporating data and evidence or information technology into their performance plans. This bill would empower agencies to integrate IT modernization and evidence metrics more effectively into their performance plans, leading to stronger outcomes. The bill also remedies the gap in expertise by instructing agencies' chief performance officers to work in consultation with the Chief Human Capital Officer, the Chief Information Officer, the Chief Data Officer, and the Chief Financial Officer to prepare the annual performance plan. The bill requires agency performance plans to include descriptions of human capital, training, data, and evidence, information technology, and skill sets needed for the agency to meet its performance goals. Finally, the bill would ensure agency performance plans include description of technology modernization investments, systems upgrades, staff technology skills and expertise, stakeholder input and feedback, and other resources and strategies needed to meet the performance goals. PIRA is endorsed by the Partnership for Public Service, the Data Foundation Alliance for Digital Innovation, and the Information Technology Industry Council. I'm also very pleased to thank my colleague and ranking member on the subcommittee, Mr. Hieist, who's an original co-sponsor of this good government bill. The bipartisan legislation, I think, is urgently needed to ensure that performance planning not only provides more precise data, but also positively influences management processes and strategic development across the federal government. I yield back the balance of my time.
The gentleman yields back. Mr. Hieist, you are now recognized. Mr. Hieist.
Thank you, Madam Chair. And I just want to say thank you to my friend from Virginia. And I hope he appreciates the humor when I say, to the extent that he was wrong on the previous bill, I appreciate the fact that he is correct and right on this one. And it's been my honor to work with him and his staff. I see you grinning, Mr. Conley, but I say that in all sincerity. I want to start off, Madam Chair, by saying and noting that this bill really is more than just smart government reform. This bill, at least to me, I think also highlights how our hearings in themselves can be, should be, and in this case actually have been the building blocks for good legislation. Specifically, this bill, the Performance Enhancement Reform Act, grew out of our subcommittee on government operations, a hearing that we had last summer dealing with federal IT modernization. And in that hearing, we listened to the witnesses and in particular, how they described how difficult it was for them, for federal agency technology resources to keep up with the large operational and programmatic changes that are taking place in the real world. And you know, the reality is that if agency leaders fail to directly involve their technology leadership in the planning process for expanding their operations or agency operations, then obviously there's going to be a much higher risk of failure. at the end of the day. And so agencies, we all know, oftentimes agencies deal with the problem of reacting to necessary mission challenges and program requirements. And frankly, many times that is a result of mandates that Congress puts on them. But still, resource constraints need to be taken into consideration, and agencies need to make sure that they have the necessary technology capabilities, supporting data assets, the human workforce capacity and skills, all these things to support the operations that are required for them to achieve mission success, whatever their particular mission may be. And so in the hearing last summer, we listened to the witnesses, we listened to the testimony, we gathered insight, we gathered information, and we responded with this bill. And it basically just requires proper agency collaboration and annual agency performance planning. Already every year, agencies create performance plans as they are required to do under the Government Performance and Results Act of 1993. And they're also required with the Government Performance and Results Modernization Act of 2010. But what happens in this particular bill, the Performance Enhancement Reform Act, this will make sure that the agency's performance planning process considers agency resources, such as information technology, data assets and evidence, workforce capability, and skills. And so the theory here is really quite simple. Agencies need to make sure that they have the tools to accomplish the task. And when you think about it, who knows better what the agency's toolbox consists of, but the various leaders there, the chief information officers, the chief data officers, the chief financial officers. And this bill simply requires that when agency chief performance improvement officers make their performance goals, that they consult with their peer leadership. There's a pure common sense here. The other agency leaders this bill requires collaboration with are best able to say whether and how a proposed agency goals are going to be able to be achieved. And so after all, I mean, what's the point of committing a goal if there's little chance of achieving the goal and having success? So this bill helps make sure that federal agencies commit to more realistic capability and resource-based performance goals. Again, I sincerely want to thank Mr. Conley for working with me on this targeted reform bill. I appreciate the Chairwoman for including it on this in this markup so early in the year. And with that, I'll yield back and urge my colleagues to support the bill. And I thank you.
Thank you. Gentleman yields back. I now recognize myself for 5 minutes. And I thank Chairman Conley and Ranking Member Hieist of the Government Operations Subcommittee for this constructive bipartisan legislation. This bill would build on the seminal Government Performance and Reform Act of 1993, which is the foundation of modern government management. Under that law, federal agencies must develop 5-year strategic plans and annual performance plans and reports. The law was updated in 2010 to require greater involvement by the Office of Management and Budget to establish government-wide priority goals and to provide greater accountability by requiring agencies to publish their plans and reports online. Agency chief performance officers are responsible for developing these strategic and performance plans. The Performance Enhancement Act, introduced by Mr. Conley and Mr. Hieist, would require chief performance officers to work in consultation with other senior agency leaders, including the chief information officer and the chief financial officer, to prepare the annual performance plans required by law. The bill also would require agency performance plans to include descriptions of any skill sets the agency needs to meet its performance goals. This would be an important reform to identify any gaps in expertise or resources needed to accomplish the agency's goals. I strongly support this common sense bipartisan improvement, that will enhance agency management and strengthen the focus on achieving the agency's mission. I yield back the balance of my time, and who else seeks? Mr. Comer, I believe you are seeking recognition now, Mr. Comer.
Madam Chair, I just simply want to echo what Representative Hieist said. I strongly support this bill, and I appreciate Mr. Hieist and Mr. Conley working together in a bipartisan way to propose and hopefully pass a good government bill. I urge everyone to support this good government bill.
Okay. The question now occurs on the amendment in the nature of a substitute offered by the gentlewoman from New York. All of those in favor say aye. Aye. All those opposed say no. In the opinion of the chair, the ayes have it, and the amendment is adopted. The question now occurs on favorably reporting H.R. 2671 as amended to the House. All those in favor say aye.
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 All those opposed say no. In the opinion of the chair, the ayes have it, and the bill is agreed to.
2671.
Okay, I now call up H.R. 3327, the No Corruption Act. The clerk will report the bill, which was distributed in advance.
H.R. 3327, the No Corruption Act.
Without objection, the bill is considered read and open to amendment at any point. The chair recognizes herself to offer an amendment in the nature of a substitute, copies of which have been distributed electronically to all members in advance. The clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 3327, offered by Ms. Maloney of New York.
Without objection, the amendment is considered read and will serve as base text for purposes of amendment. I now recognize the sponsor of the legislation, Mr. Norman, for 5 minutes. Mr. Norman.
Thank you, Chairman Maloney. This is a pretty straightforward bill that I think will restore the faith in politicians who end up getting convicted of a crime. They return their pensions. The reason I say restore the faith, because a lot of politicians have gotten into trouble, are still getting their money, which they shouldn't have. They would refund it during the time it's under appeal, or at the time that if they're convicted. And I think this will help put the faith back in the system, which I think we've lost over the years, both Republican and Democrat. And would hope this would meet the favor of the committee. I yield back.
The No Corruption Act, which I'm proud to co-sponsor, closes a loophole in the current law that allows former members of Congress who've been convicted of a crime to continue collecting pension benefits until they have been sentenced. The time period between conviction and sentencing can take several months or much longer if the member appeals the conviction. It's an outrageous loophole that shouldn't exist. These are former members who have already been convicted of a crime, and they're still receiving taxpayer-funded pension purely because of a technicality in the law that says they don't lose their pensions until they've been sentenced. This bill would close this loophole by clarifying that any former member convicted of a crime, after enactment of this bill, pension payments should be terminated upon initial conviction. Of course, if the conviction is later overturned, any withheld pension payments would be reimbursed to the member. This bipartisan measure was introduced by Congressman Ralph Norman last week with bipartisan co-sponsors, including a ranking member Comer and myself. The bill closes the door on a potential abuse of taxpayer funds, and I'm pleased that it has the support from both sides of the aisle on this committee. I urge my colleagues to support this bill, and I yield back. Who else seeks recognition? Mr. Comer, you're now recognized.
Thank you, Madam Chair. I commend Representative Norman, the ranking member of the Subcommittee on Environment and Energy, for sponsoring this bill. I think if you polled this bill, it would have nearly 100% support among the public in both parties. We've seen a string of cases involving former members of Congress, and we've had legislation pass Congress to prohibit pension payments for members who are found guilty of certain crimes. However, the text of those underlying laws allowed convicted members to continue to collect their federally funded pension until their, quote, final conviction, meaning they could keep whatever federally funded pension money they received during the pendency of their legal appeals, which could stretch out for many years. So the No Corruption Act, sponsored by Ralph Norman, amends current law to require members to forfeit any federally funded pensions collected after their sentencing, but prior to their exhaustion of appeals if those appeals were ultimately denied and their convictions upheld. Again, this is a good government bill. This defends the taxpayers of America, holds bad politicians accountable, and I commend Mr. Norman for sponsoring this bill and encourage everyone to strongly support this bill. I yield back.
The gentleman yields back. Who else seeks recognition? Mr. Grossman.
Madam Chairman.
You're now recognized, Mr. Grossman.
Yeah, thanks. I'm sure this is a very popular bill.
Oh, excuse me. Mr. Sessions, you're now recognized.
Madam Chairman, thank you very much. I'd like to ask a question, if I could, at this time, and when that's in order, Madam Chairman, please advise.
Gentleman is recognized.
Thank you very much. Mr. Norman or anyone else, I'd like to ask a question. We've got, that I'm aware of, at least one member of Congress that has been convicted and potentially may be out or may have left service as a result of a claim of a disability or a claim of some kind. Does this include all members of Congress for any reason why they may be receiving a pension?
Madam Chair, may I answer that?
Yes, you are now recognized.
Yeah, Congressman Sessions, I think it would apply for whatever reason. If they've got a grave enough offense to be expelled from Congress for whatever reason, then they shouldn't get their pensions. And so, yes, I would say it would. I can't think of an example that, you know, would merit for them to keep receiving the pension. So, yes, my interpretation of it would be yes. I yield back.
Thank you, Madam Chairman. This is important because, as you know, the intent of Congress many times would be looked at by a court. And in one case of circumstances that I'm aware of, this member of Congress took some leave of absence, went at some point either to receive counseling or something of the nature, perhaps it was substance abuse. And then subsequently to that, they were then no longer ran for Congress, and I believe out on disability. So I agree with Congressman Norman that I believe the intent, his intent when he's writing this, and we as writing this as members of Congress, believe that no matter the reason, that if a person were at some point convicted of these offenses enumerated, regardless of the circumstances that they had previously left, would be held accountable. And I appreciate the gentleman clarifying that. And those members of Congress that are in here need to be aware that that is the intent of the gentleman's amendment, and I am supportive of that. And I thank you very much, Madam Chairman.
Mr. Grossman, do you seek recognition?
Sure.
Yes, you're now recognized. Okay, then, Mr. Biggs, we couldn't hear you. Mr. Biggs, do you seek recognition?
No, ma'am. Madam Chair, I've lowered my hand.
Okay, all right. Then the question now occurs on the amendment in the nature of a substitute offered by the gentlelady from New York. All those in favor say aye. Aye.
Aye.
All those opposed say no. In the opinion of the chair, the ayes have it, and the amendment is adopted.
Madam Chair,
Yes.
may I ask for the yeas and nays?
A recorded vote has been requested. A recorded vote is so ordered pursuant to Clause 2 of Rule 11. and Committee Rule 5B. Proceedings on the amendment are postponed. The question now occurs on, okay. I now call up H.R. 1297, the Air America Act. The clerk will report the bill, which was distributed in advance.
H.R. 1297, the Air America Act.
Without objection, the bill is considered read and open to amendment at any point. The chair recognizes herself to offer an amendment in the nature of a substitute, copies of which have been distributed electronically to all members in advance. The clerks will report the amendment.
Amendment in the nature of a substitute to H.R. 1297, offered by Ms. Maloney of New York.
Without objection, the amendment is considered read and will serve as a base text for purposes of amendment. I now recognize the sponsor of the legislation, Mr. Grossman, for 5 minutes. You are muted, Mr. Grossman. You are muted. We cannot hear you.
Yeah,
Please unmute. We cannot hear you. Mr. Grossman, can you call?
should be on your end.
I now recognize myself. We have some technicalities with Mr. Grothman. The Air America Act would grant federal employee status to employees of Air America, Inc., who flew covert missions associated with military operations in Southeast Asia between 1950 to 1976. The employees of Air America have never been recognized as federal employees and therefore were never deemed eligible to receive a federal pension. As a result of recently declassified reports, we now know more about the status of Air America as a U.S. government-owned entity. And it's now clear that while their employees were nominally working for Air America, they were really working for the federal government. This legislation would classify time employed by Air America as credible service, making those employees or their heirs eligible for federal retirement benefits. More than 100 bipartisan co-sponsors have signed on to support this bill introduced by Congressman Glenn Grothman in February. The Senate companion bill currently has 29 bipartisan co-sponsors. I am pleased to support this legislation, and I urge all my colleagues to support it. I yield back. Who else seeks recognition?
Can you hear me now?
We can hear you now, Mr. Grothman. You are now recognized.
Okay, we did such a wonderful job of covering that bill. I just want to speak briefly one more time on behalf of the Air America employees. There are about 1,000 people who flew for Air America. This will only cover about the 500 that are left still alive. They were very important to what we were doing in Laos, as well as at the end of the Vietnam War. Certainly very important for the Hmong, who provided a great deal of assistance to us during the war. And I'd like to thank the chairwoman for bringing this bill up for a vote.
Who else seeks recognition? Who else seeks recognition?
Madam Chair,
Mr. Norman, you're now recognized.
thank you. I have a question. If the numbers of people affected are 500, how is the pay determined? Is it, would you index it back to, I think, Glenn, you said the 50s and through the 70s, and is it extended to heirs as indefinitely?
It is a pension only if you're still around to collect the pension. So the 500 people who are deceased are not getting out of the bill.
Okay, and how's the dollar amount figured?
I think it varies from pilot to pilot, and to a certain extent, it depends whether or not you have government service after that.
Okay, yeah, I support the bill. I think it's important to do the math and see, you know, what the pensions would be a lot less back in the 50s and 60s than they are today. I don't know if your bill, if you cover that, Glenn, but I think that would be spell it out both for the recipients and for the taxpayers. I yield back.
Okay.
The gentleman yields back. The question now occurs on the amendment in the nature of a substitute offered by the gentlewoman from New York. All those in favor say aye.
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 All those opposed say no. In the opinion of the chair, the ayes have it, and the amendment is adopted. Okay. The question now occurs on favorably reporting H.R. 1297 as amended to the House. All those in favor say aye. Aye.
Aye.
All those opposed say no. In the opinion of the chair, the ayes have it, and the bill is agreed to. Mr. Comer, it just came to my attention that you would like to speak on the bill? And he's saying no now. Okay. I now call up H.R. 3367, the Gold Star Children's Act. The clerk will report the bill, which was distributed in advance.
H.R. 3367, the Gold Star Children Act.
Without objection, the bill is considered read and open to amendment at any point. The chair recognizes herself to offer an amendment in the nature of a substitute, copies of which have been distributed electronically to all members in advance. The clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 3367, offered by Ms. Maloney of New York.
Without objection, the amendment is considered read, and I will serve it as a base text for the purposes of amendment. I now recognize myself for 5 minutes. The Gold Star Children's Act would honor the sacrifices of our fallen service members, as well as permanently and totally disabled veterans, by extending federal hiring preferences to their children. I want to thank Representatives Taylor and Wasserman Schultz for introducing this bipartisan legislation. Congress enacted preferences for veterans in federal hiring to recognize the sacrifices that our veterans have made and to acknowledge the debt that this country owes them. Veterans' preference is also extended to certain spouses or parents of veterans who have served during wars or in military campaigns or who have a service-connected total disability. But under current law, children of these veterans are not eligible for this preference, and this is just plain wrong. There are more than 15,000 children in the United States right now who have lost a mother or father to war. Many other children have a parent who was permanently and totally disabled as a result of their military service. These children have suffered tremendously. The loss of a parent is a traumatic experience and something that will stay with them for the rest of their lives. The bill would finally right this wrong by extending the veterans' preference to these children in recognition of the sacrifice that they too have endured. I strongly support this measure and now recognize Representative Comer, the co-lead of this bill, for 5 minutes.
Thank you, Madam Chair. Our federal workforce greatly benefits from the skills and talents of veterans and their families. Congress passed the Veterans Preference Act of 1944, which put in law the principle that we should honor and take care of those veterans who sacrificed and served. Even before that, according to the Office of Personnel Management, veterans have been given a degree of preference in federal hiring since the time of the Civil War. The veterans preference enables eligible federal employment candidates who are fully qualified and have the proper examination score to be given a few extra points compared to other candidates. This process ensures that our government can retain the skilled workforce it needs by leveraging the experience and talent of highly trained veterans. Veterans also often forego or delay other employment opportunities while they serve their country in the armed forces to protect our nation. It makes sense that we recognize the sacrifices they have made and ensure qualified candidates are not disadvantaged when it comes to hiring for competitive service positions in the federal government. Additionally, some of our service members make the ultimate sacrifice, while other veterans become permanently and totally disabled because of their military service. The surviving families of these veterans who make that ultimate sacrifice are known as Gold Star families. Recognizing that Gold Star families are greatly impacted by their loss, Congress has provided spouses and parents of those veterans federal hiring preference for competitive service positions. Yet federal law does not extend that preference to the children of deceased or permanently and totally disabled veterans. It's clear that the children of veterans who die or become disabled as a result of their service in the armed forces will face incredible hardships. They have endured a trauma that our country should never forget. That's why I'm proud to support Congressman Taylor's Gold Star Children Act. The Gold Star Children Act is a straightforward bill that simply states that children of veterans who lost their lives under honorable conditions while serving during a period of conflict are eligible for a veteran's preference in federal hiring. It would also cover children of service veterans who become permanently and totally disabled due to their service. Our federal workforce benefits from the skills and talents of veterans and their family members. This bill will help America honor the memory of those who made the ultimate sacrifice by ensuring that children are able to bring their experiences, talents, and skills to the American people's federal government. I appreciate Congressman Taylor's leadership on this bill, and I urge members to support it. I yield back.
Who else seeks recognition? Without anyone seeking recognition, the question now occurs. She's in the waiting room. Please let Mrs. Wasserman Schultz into the Zoom. She says she's in the waiting room. Okay. The question now occurs on the amendment in the nature of a substitute offered by the gentlewoman from New York. All those in favor say aye. Aye. All those opposed? Aye. All those opposed say no. In the opinion of the chair, the ayes have it, and the amendment is adopted. The question now occurs on favorably reporting H.R. 3367 as amended to the House. All those in favor say aye. Aye.
Aye.
All those opposed say no. In the opinion of the chair, the ayes have it, and the bill is agreed to it. There being no further discussion or amendments, the committee will now stand in recess until 5 o'clock, when we will reconvene for roll call votes on pending amendments and final passage. The committee stands in recess until 5 p.m. Committee will come to order. During the recess, Mr. Norman withdrew his request for a recorded vote on the substitute amendment to H.R. 3327. Without objection, Mr. Norman's request for a recorded vote is vitiated, and the question now occurs on favorability reporting H.R. 3327 as amended to the House. All those in favor say aye.
Aye.
Aye. All those opposed say no. In the opinion of the chairs, the ayes have it, and the bill is agreed to it. The question now occurs on the Biggs Amendment to H.R. 2662, which previously failed by voice vote. The clerk will call the roll.
Ms. Norton?
No.
Ms. Norton votes no. Mr. Lynch?
Mr. Lynch votes no.
Mr. Lynch votes no. Mr. Cooper? Mr. Connolly?
Mr. Conley votes nay.
Mr. Connolly votes no. Mr. Krishnamurthy?
No.
Mr. Krishnamurthy votes no. Mr. Raskin?
No.
Mr. Raskin votes no. Mr. Khanna?
No.
Mr. Khanna votes no. Mr. Mfume? Ms. Ocasio-Cortez?
Ocasio-Cortez votes no.
Ms. Ocasio-Cortez votes no. Ms. Tlaib? Ms. Porter?
Votes no.
Ms. Tlaib votes no. Ms. Porter?
No.
Ms. Porter votes no. Ms. Bush?
Ms. Bush votes no.
Ms. Bush votes no. Mr. Davis? Ms. Wasserman Schultz? Mr. Welch?
I'm sorry, Wasserman Schultz votes no.
Ms. Wasserman Schultz votes no. Mr. Welch?
No.
Mr. Welch votes no. Mr. Johnson?
No.
Mr. Johnson votes no. Mr. Sarbanes? Mr. Sarbanes? Ms. Spear? Ms. Kelly?
No.
Ms. Kelly votes no. Ms. Lawrence?
Lawrence votes no.
Ms. Lawrence votes no. Mr. DeSagne? Mr. Gomez?
Gomez, no.
Mr. Gomez votes no. Ms. Presley? Mr. Quigley?
Quigley votes no.
Mr. Quigley votes no. Mr. Comer?
Comer votes yes.
Mr. Comer votes yes. Mr. Jordan? Mr. Gosar? Ms. Fox?
Yes.
Ms. Fox votes yes. Mr. Hieist?
Yes.
Mr. Hieist votes yes. Mr. Grothman?
Yes.
Mr. Grothman votes yes. Mr. Cloud? Mr. Gibbs?
Yes.
Mr. Gibbs votes yes.
Yes.
Mr. Higgins?
Mr. Jordan votes yes.
Mr. Jordan, you're not on camera. Mr. Higgins? Mr. Norman?
Ms. Norman votes votes no, votes yes.
I'm sorry, can you repeat that one more time?
Ms. Norman votes yes.
Mr. Norman votes yes. Mr. Sessions?
Sessions, aye.
Mr. Sessions votes yes. Mr. Keller?
Keller votes yes.
Mr. Keller votes yes. Mr. Biggs?
Yes.
Mr. Biggs votes yes. Mr. Clyde?
Yes.
Mr. Clyde votes yes. Ms. Mace? Mr. Franklin?
Franklin votes aye.
Mr. Franklin votes yes. Mr. Laturner?
Yes.
Mr. Laturner votes yes. Mr. Fallon?
Fallon votes yes.
Mr. Fallon votes yes. Ms. Harrell?
Ms. Harrell votes yes.
Ms. Harrell votes yes. Mr. Donalds? Ms. Maloney?
How am I recorded, Madam Chair?
Mrs. Maloney votes no.
Ms. Maloney votes no.
Madam Chair, how am I recorded, Congressman Sarbanes?
Mr. Sarbanes, you are not recorded.
Sarbanes votes no.
Mr. Sarbanes votes no.
Madam Chair, this is Congressman Jordan. Yes.
Mr. Jordan votes yes.
Is there any member who has not voted? Is there any member wishing to change his or her vote? DeSanya? Mr. DeSanya?
No.
Mr.
DeSanya votes no.
Mr. DeSanya votes no.
Okay, if no one wishes to change their vote, will the clerk report the vote?
On this vote, we have 15 yeas and 20 nays.
The amendment is not agreed to, and the motion to reconsider is laid on the table. The question now occurs on the Keller amendment to H.R. 2662, which previously failed by a voice vote. The clerk will call the roll.
Ms. Norton?
Ms. Norton votes no.
Ms. Norton votes no. Mr. Lynch?
Mr. Lynch votes no.
Mr. Lynch votes no. Mr. Cooper? Mr. Connolly?
Conley votes nay.
Mr. Connolly votes no. Mr. Krishnamurthy?
No. No.
Mr. Krishnamurthy votes no. Mr. Raskin?
Raskin votes no.
Mr. Raskin votes no. Mr. Khanna?
No.
Mr. Khanna votes no. Mr. Mfume? Ms. Ocasio-Cortez?
Ocasio-Cortez votes no.
Ms. Ocasio-Cortez votes no. Ms. Tlaib?
Ms. Tlaib votes no.
Ms. Tlaib votes no. Ms. Porter?
No.
Ms. Porter votes no. Ms. Bush?
Bush votes no.
Ms. Bush votes no. Mr. Davis? Ms. Wasserman Schultz?
Wasserman Schultz votes no.
Ms. Wasserman Schultz votes no. Mr. Welch?
Votes no.
Mr. Welch votes no. Mr. Johnson?
No.
Mr. Johnson votes no. Mr. Sarbanes?
Sarbanes votes no.
Mr. Sarbanes votes no. Ms. Spear? Ms. Kelly?
Kelly votes no.
Ms. Kelly votes no. Ms. Lawrence?
Lawrence votes no.
Ms. Lawrence votes no. Mr. DeSagne?
DeSagne votes no.
Mr. DeSagne votes no. Mr. Gomez?
No.
Mr. Gomez votes no. Ms. Presley? Mr. Quigley?
Quigley votes no.
Mr. Quigley votes no. Mr. Comer?
Comer votes yes.
Mr. Comer votes yes. Mr. Jordan?
Yes.
Mr. Jordan votes yes. Mr. Gosar? Ms. Fox?
Ms. Fox votes yes.
Ms. Fox votes yes. Mr. Hieist?
Yes.
Mr. Hieist votes yes. Mr. Grothman? Mr. Cloud?
Yes.
Mr. Cloud votes yes. Mr. Gibbs?
Gibbs, yes.
Mr. Gibbs votes yes. Mr. Higgins? Mr. Norman?
Norman votes yes.
Mr. Norman votes yes. Mr. Sessions?
Sessions, aye.
Mr. Sessions votes yes. Mr. Keller?
Keller votes yes.
Mr. Keller votes yes. Mr. Biggs?
Yes.
Mr. Biggs votes yes. Mr. Clyde?
Yes.
Mr. Clyde votes yes. Ms. Mace?
Yes.
Ms. Mace votes yes. Mr. Franklin?
Franklin votes aye.
Mr. Franklin votes yes. Mr. LaTurner?
Yes.
Mr. LaTurner votes yes. Mr. Fallon?
Allen votes yes.
Mr. Fallon votes yes. Ms. Harrell?
Ms. Harrell votes yes.
Ms. Harrell votes yes. Mr. Donalds?
Mr. Donalds votes yes.
Mr. Donalds votes yes. Ms. Maloney?
No. Maloney votes no.
Ms. Maloney votes no.
Is there any member who has not voted?
Mr. Grothman votes yes if I didn't hear you the first time.
Mr. Grothman votes yes.
Is there any member?
Madam Chair, how am I recorded?
Ms. Spear is not recorded.
Ms. Spear votes no.
Ms. Spear votes no.
Is there any member wishing to change his or her vote? If not, the clerk will report the vote.
On this vote, we have 18 ayes and 21 nays.
The amendment is not agreed to, and the motion to reconsider is laid on the table. The question now occurs on the amendment in the nature of a substitute to H.R. 2662. All those in favor say aye.
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 All those opposed say no.
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 No. Madam Chair, I call for a roll call vote.
Okay, well,
That's an aye, isn't it?
this is the substitute amendment.
Okay,
So in the opinion of the chairs, the ayes have it, and the amendment is in the nature of a substitute is agreed to. All right, the question now occurs on H.R. 2662 as amended. All those in favor say aye.
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 All those opposed say no.
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 In the opinion of the chair, the ayes have it, and the bill is agreed to.
Madam Chair,
Okay.
we request a roll call vote on that.
A recorded vote has been requested. A recorded vote is ordered. The clerk will call the roll.
5. Okay, so do you have it up?
Ms. Norton?
Ms. Norton votes aye.
Ms. Norton
Are
votes
you up
aye.
on yours? Yeah, come on.
Mr. Lynch?
Mr. Lynch votes aye.
Mr. Lynch votes aye. Mr. Cooper? Mr. Connolly?
Connolly votes aye.
Mr. Connolly votes aye. Mr. Krishnamurthy?
Aye.
Mr. Krishnamurthy votes aye. Mr. Raskin?
Aye.
Mr. Raskin votes aye. Mr. Khanna?
Aye.
Mr. Khanna votes aye. Mr. Mfume? Ms. Ocasio-Cortez?
Aye.
Ms. Ocasio-Cortez votes aye. Ms. Tlaib?
Ms. Tlaib votes yes.
Ms. Tlaib votes aye. Ms. Porter?
Yes.
Ms. Porter votes aye. Ms. Bush?
Ms. Bush votes aye.
Ms. Bush votes aye. Mr. Davis? Ms. Wasserman Schultz?
Wasserman Schultz votes aye.
Ms. Wasserman Schultz votes aye. Mr. Welch?
Aye.
Mr. Welch votes aye. Mr. Johnson?
Aye.
Mr. Johnson?
Johnson votes aye.
Mr. Johnson votes aye. Mr. Sarbanes?
Sarbanes votes aye.
Mr. Sarbanes votes aye. Ms. Spear?
Spear votes aye.
Ms. Spear votes aye. Ms. Kelly?
Kelly votes aye.
Okay.
Ms. Kelly votes aye. Ms. Lawrence?
Lawrence votes aye.
Ms. Lawrence votes aye. Mr. DeSaulnier? Mr. DeSaulnier? Mr. Gomez?
No.
Mr. Gomez?
Hold on.
Ms. Presley? Mr. Quigley?
Quigley votes aye.
Mr. Quigley votes aye. Mr. Comer?
Comer votes no.
Mr. Comer votes no. Mr. Jordan?
No.
Mr. Jordan votes no. Mr. Gosar? Ms. Fox?
Ms. Fox votes no.
Ms. Fox votes no. Mr. Hieist?
No.
Mr. Hieist votes no. Mr. Grothman?
No.
Mr. Grothman votes no. Mr. Cloud?
DeSaulnier, aye.
No.
Mr. Cloud votes no. Mr. Gibbs?
No.
Mr. Gibbs
Aye.
votes no. Mr. Higgins?
Votes aye.
Mr. Higgins? Mr. Norman?
Norman votes no.
Mr. Norman votes no. Mr. Sessions?
Sessions votes no.
Mr. Sessions votes no. Mr. Keller?
Keller votes no.
Mr. Keller votes no. Mr. Biggs?
No.
Mr. Biggs votes no. Mr. Clyde?
No.
Mr. Clyde votes no. Ms. Mace?
No.
Ms. Mace votes no. Mr. Franklin?
Franklin votes no.
Mr. Franklin votes no. Mr. LaTurner?
No.
Mr. LaTurner votes no. Mr. Fallon?
Fallon votes no.
Mr. Fallon votes no. Ms. Harrell?
Ms. Harrell votes no.
Ms. Harrell votes no. Mr. Donalds?
No.
Mr. Donalds votes no. Ms. Maloney?
Maloney votes aye.
Ms. Maloney
Madam
votes.
Chair, how am I recorded?
Mr. Gomez, you are not recorded.
Gomez, aye.
Mr. Gomez votes aye.
Madam Chair, this is
aye.
Cooper. How am I recorded?
Mr. Cooper, you are not recorded.
I vote aye.
Mr. Cooper votes aye.
Madam Chair, how am I recorded, please?
Mr. DeSaulnier, you are not recorded.
DeSaulnier votes no, please.
No, you vote aye.
I'm sorry. DeSaulnier, aye.
Is there any member who has not voted?
Madam Chair, could we have a clarification of how Mr. Higgins voted?
Mr. Higgins did not vote.
I believe Mr. Higgins did speak up, but okay, thank you.
And how did Mr. Welch vote? How am I recorded?
Voice the rest.
Mr. Welch, you voted aye.
Thank you.
Is there any member wishing to change his or her vote? The clerk will report the tally when ready.
On this vote, we have 22 ayes and 18 nays.
H.R. 2662 as amended shall be favorably reported to the House. Without objection, a motion to reconsider is laid on the table. Staff is authorized to make any technical and conforming changes. The question now occurs on the Hieist Amendment to H.R. 302, which previously failed by voice vote. The clerk will call the roll.
Ms. Norton?
Ms. Norton votes no.
Ms. Norton votes no. Mr. Lynch?
Bruce votes no.
Mr. Lynch votes no. Mr. Cooper?
Cooper votes no.
Mr. Cooper votes no. Mr. Connolly?
Connolly votes nay.
Mr. Connolly votes no. Mr. Krishnamurthy?
No. No.
Mr. Krishnamurthy votes no. Mr. Raskin?
No.
Mr. Raskin votes no. Mr. Khanna?
No, no.
Mr. Khanna votes no. Mr. Mfume? Ms. Ocasio-Cortez?
Ocasio-Cortez votes no.
Ms. Ocasio-Cortez votes no. Ms. Tlaib?
Tlaib votes no.
Ms. Tlaib votes no. Ms. Porter?
No.
Ms. Porter votes no. Ms. Bush?
Bush votes no.
Ms. Bush votes no. Mr. Davis? Ms. Wasserman Schultz?
Wasserman Schultz votes no.
Ms. Wasserman Schultz votes no. Mr. Welch?
No.
Mr. Welch votes no. Mr. Johnson?
No.
Mr. Johnson votes no. Mr. Sarbanes?
Fire department wants us to.
Sarbanes votes no.
Mr. Sarbanes votes no. Ms. Spear?
Spear votes no.
Ms. Spear votes no. Ms. Kelly?
Kelly is a nay.
Ms. Kelly votes no. Ms. Lawrence?
Lawrence votes no.
Ms. Lawrence votes no. Mr. DeSaulnier?
Sonia votes no.
Mr. DeSaulnier votes no. Mr. Gomez?
Gomez votes no.
Mr. Gomez votes no. Ms. Presley? Mr. Quigley?
Quigley votes no.
Mr. Quigley votes no. Mr. Comer?
Comer votes yes.
Mr. Comer votes yes. Mr. Jordan?
Yes.
Mr. Jordan votes yes. Mr. Gosar? Ms. Fox?
Ms. Fox votes yes.
Ms. Fox votes yes. Mr. Hieist? Mr. Grothman?
Yeah.
Mr. Grothman votes yes. Mr. Cloud?
Yes.
Mr. Cloud votes yes. Mr. Gibbs?
Yes.
Mr. Gibbs votes yes. Mr. Higgins?
Yes.
Mr. Higgins? Mr. Norman?
Norman votes yes.
Mr. Norman votes yes. Mr. Sessions?
Mr. Sessions, aye.
Mr. Sessions votes yes. Mr. Keller?
Keller votes yes.
Mr. Keller votes yes. Mr. Biggs?
Aye.
Mr. Biggs votes yes. Mr. Clyde?
Mr. Clyde votes yes.
Mr. Clyde votes yes. Ms. Mace?
Aye.
Ms. Mace votes aye. Mr. Franklin?
Franklin votes aye.
Mr. Franklin votes aye. Mr. Laturner?
Aye.
Mr. Laturner votes aye. Mr. Fallon?
Fallon votes aye.
Mr. Fallon votes aye. Ms. Harrell?
Ms. Harrell votes yes.
Ms. Harrell votes yes. Mr. Donalds?
Yes.
Mr. Donald, you're not on camera.
Yes.
Mr. Donalds votes yes. Ms. Maloney?
Maloney votes no.
Ms. Maloney votes no.
Did you get Hieist? Yes.
Mr. Hieist, you are not recorded.
Yes.
Mr. Hieist votes yes.
Is there any member who has not voted? Is there any member wishing to change his or her vote? If not, the clerk will report the vote.
On this vote, we have 18 ayes and 22 nays.
The amendment is not agreed to. The motion to reconsider is laid on the table. The question now occurs on the amendment in the nature of a substitute to H.R. 302. All those in favor say aye.
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 All those opposed say no.
No.
In the opinion of the chair, the ayes have it, and the amendment in the nature of a substitute is agreed to. Is there any, okay, the amendment in the nature of a substitute is agreed to. The question now occurs on H.R. 302 as amended. All those in favor say aye.
Aye.
All those opposed say no.
No.
In the opinion of the chair, the ayes have it. The bill is agreed to.
Madam,
Yes?
Chair. Madam Chair, on that, I ask for a recorded vote.
A recorded vote has been requested. A recorded vote is ordered. The clerk will call the roll.
Ms. Norton?
Ms. Norton votes aye.
Ms. Norton votes aye. Mr. Lynch?
Mr. Lynch votes aye.
Mr. Lynch votes aye. Mr. Cooper?
Cooper votes aye.
Mr. Cooper votes aye. Mr. Connolly?
Mr. Conley votes aye.
Mr. Connolly votes aye. Mr. Krishnamurthy?
Aye.
Mr. Krishnamurthy votes aye. Mr. Raskin?
I vote aye.
Mr. Raskin votes aye. Mr. Khanna?
Aye.
Mr. Khanna votes aye. Mr. Mfume? Ms. Ocasio-Cortez?
Aye.
Ms. Ocasio-Cortez votes aye. Ms. Tlaib?
Tlaib votes yes.
Ms. Tlaib votes aye. Ms. Porter?
Tlaib votes aye. Ms. Porter.
Yes.
Ms. Porter votes aye. Ms. Bush? Mr. Davis?
Davis votes aye.
Mr. Davis votes aye. Ms. Wasserman Schultz?
Wasserman Schultz votes aye.
Ms. Wasserman Schultz votes aye. Mr. Welch?
Aye.
Mr. Welch votes aye. Mr. Johnson?
Aye.
Mr. Johnson votes aye. Mr. Sarbanes?
Sarbanes votes aye.
Mr. Sarbanes votes aye. Ms. Spear?
Spear votes aye.
Ms. Spear votes aye. Ms. Kelly?
Kelly votes aye.
Ms. Kelly votes aye. Ms. Lawrence?
Lawrence votes aye.
Ms. Lawrence votes aye. Mr. DeSaulnier?
DeSaulnier votes aye.
Mr. DeSaulnier votes aye. Mr. Gomez?
Gomez, aye.
Mr. Gomez votes aye. Ms. Presley? Mr. Quigley?
Quigley votes aye.
Mr. Quigley votes aye. Mr. Comer?
Comer votes no.
Mr. Comer votes no. Mr. Jordan?
No.
Mr. Jordan votes no. Mr. Gosar? Mr. Fox?
Ms. Fox votes no.
Ms. Fox votes no. Mr. Hieist?
No.
Mr. Hieist votes no. Mr. Grothman?
no,
Mr. Grothman votes no. Mr. Cloud?
No.
Mr. Cloud votes no. Mr. Gibbs?
Gibbs votes no.
Mr. Gibbs votes no. Mr. Higgins? Mr. Norman?
Norman votes no.
Mr. Norman votes no. Mr. Sessions?
Sessions, no.
Mr. Sessions votes no. Mr. Keller?
Keller votes no.
Mr. Keller votes no. Mr. Biggs?
No.
Mr. Biggs votes no. Mr. Clyde?
no,
Mr. Clyde votes no. Ms. Mace?
No.
Ms. Mace votes no. Mr. Franklin?
Franklin votes no.
Mr. Franklin votes no. Mr. Laturner?
No.
Mr. Laturner votes no. Mr. Fallon?
Fallon votes no.
Mr. Fallon votes no. Ms. Harrell?
Ms. Harrell votes no.
Ms. Harrell votes no. Mr. Donalds?
No.
Mr. Donalds votes no. Ms. Maloney?
Maloney votes aye.
Ms. Maloney votes aye.
Is there any member who has not voted? Is there any member wishing to change his or her vote? The clerk will report the tally when ready.
On this vote, we have 22 ayes and 18 nays.
H.R. 302 as amended shall be favorably reported to the House. Without objection, a motion to reconsider is laid on the table. Staff is authorized to make any technical and conforming changes. Now we have one final piece of business that I will dispense with very quickly. Pursuant to notice, I call up the following postal naming bills, which were distributed in advance. H.R. 207, 209, 3175, 3210, and 2419. Without objection, the bills are considered read, and I request unanimous consent for their immediate consideration in block. Without objection, the bills are passed. Staff is authorized to make technical and conforming changes to the bills considered in this markup. With that, there is no further business of the committee, so I want to say thank you all for your participation today, and the committee stands adjourned.